right. Good morning, everyone.
Good morning.
Good morning.
We're here on Records versus Records, 20 DR 1535 for what is likely to be the last Zoom trial. Please enter your appearances.
Kirby representing the wife, Sharon Records.
Suzanne Lanier representing Richard Records, the husband who is seated to my right.
Okay. So we're here for the second day of trial. Obviously, there was a ruling in the first day. So what I'd like to do is just have these initial openings from either side explaining to me what is still at issue and what the court needs to decide today, beginning with you, Ms. Kirby.
Thank you, Your Honor. Good morning.
Good morning.
It's Lisa Kirby. My client is Sharon Records, the wife. The parties are asking this court to dissolve their marriage. The parties were married August 25th, 1985 in Ohio, which, you know, they lived together as husband and wife until their final separation on or about July or August 2020. They were married August 25th when Mrs. Records permanently moved out of the house at the marital residence in July or August 2020. Prior to the parties' marriage, they signed a prenuptial agreement, which the wife contested and which this court found to be valid pursuant to a court order dated April 22nd, 2021. Yes, I know you just asked for, I just want to put it on the record.
Yeah.
The wife filed her petition on August 13th, 2020, and she amended her petition on February 2nd, 2021 to request alternative relief of alimony. The parties have no children. The parties have marital assets and non-marital assets on the equitable distribution worksheet, and the parties disagree as to what is marital and what is non-marital equitable assets. While there are other marital assets that the parties also disagree on, the four main issues today, well, all of them are important issues, but the four main issues are number one, the house on Mission Drive. The parties previously stipulated that the deed had to go into the husband's name. Parties do not agree on whose property it is, but they did stipulate that because it was a 1031 exchange, it had to go into the husband's name. The cost of acquisition of that house was $550,000. The cost of that acquisition was paid for two ways: a 1031 exchange and a note that was secured by a mortgage. The husband's premarital property was used in the 1031 exchange. The wife is on the note and the mortgage for the home. The husband is on the deed as stipulated. You will hear that pursuant to the parties' antenuptial agreement, that the property is to be divided pursuant to the cost of acquisition. We have put in our equitable distribution spreadsheet that Mr. Records would receive the first $271,000 or $270,000 from the 1031, and that the remainder should be split between the parties pursuant to the terms of the antenuptial agreement. I have provided case law. I see your skepticism, Your Honor, on your face already.
No,
And I have provided case law to you that shows what cost of acquisition is, and it does include the mortgage, and that is from Ohio. The wife is requesting that the home be sold. As you know, equitable distribution allows the court to determine the ownership of the property at the time, and that the name on the deed does not necessarily mean ownership of the property. The wife is requesting that the home be sold, that the husband be reimbursed the $270,000 for his premarital portion, and that the parties equally divide the remaining net proceeds following the payoff of the mortgage. Your Honor, we are also asking that if the court determines that pursuant to the facts that you will hear today, the court determines that the entire house was a gift, which we think the court could determine based on the law in the state of Ohio, you will see and hear that the husband specifically told the wife that the house was theirs. You will see written proof of that. And Mrs. Records needs to be off the mortgage. The second issue the parties do not agree on is the ownership of the wife's trailer. Pursuant to the antenuptial agreement, Ohio law controls, although I will tell the court that Ohio law and Florida law are very similar. The trailer is titled in the wife's name. The antenuptial agreement states that in the event of a divorce, any motor vehicle belongs to the party to whom it is titled. Ohio law considers a trailer a motor vehicle. Her motor home is a motor vehicle. The opposing counsel provided a lot of case law that said it could be considered real property. But in all of those cases, the owner of the trailer owned the real property. The law is clear. The statute in the state of Ohio is clear. Mrs. Records' trailer, which is titled in her name under Florida motor vehicle law, is a motor vehicle, and the antenuptial agreement awards it to her. The third issue, the parties do not.
Oh, hold on 1 second. Are you saying is Florida law and Ohio law the same on that issue? That the trailer is a
mobile
vehicle?
home is considered a vehicle, yes, a motor vehicle.
Okay.
But I don't think it matters. It's Ohio law. We've asked the court to take judicial notice and provided that law to the court. The third issue the parties do not agree on is the distribution of money in a Capital One money market account. Now, this is an alternative argument. We have on our equitable distribution sheet that it would be split. However, it is the wife's position today that pursuant to the antenuptial agreement, those proceeds are from the sale of non-marital property. Those proceeds were put into a joint account for a short period of time and then removed. The wife is requesting that you find the proceeds non-marital as part of her non-marital home that she exchanged during the marriage. Alternatively, she is requesting that she be awarded those proceeds as lump sum alimony for the reasons you will hear at trial today. I thought those were the three main issues. On Tuesday, I received a new equitable distribution worksheet from Mr. Records. In that equitable distribution worksheet, Mr. Records is asking that the wife's father, the inheritance she received from her father, $58,000, be considered marital. Now, what I understand, from what I understand, there was $70,000 in the account. Mrs. Records, the parties had no money. They were trying to start, they could not pay their bills. They were trying to sell Auto Options, which was a business owned by Mr. Records. And so they didn't have money to pay the bills, and they wanted the bills to come from their personal account. So Mrs. Records transferred some money over to their personal account to pay those bills for Auto Options. And then when they had the money, she transferred $20,000 back into her account. And you'll see the records, you'll see that it was used to pay for Mr. Records' business and the Mission Drive house. And then it was put back in. It was not a gift. It was to get them over a time where they didn't have the money, and she put it back in. However, even if, in addition to the equitable distribution worksheet, my client was supposed to be awarded 83, well, forget about that for right now. Your Honor, we're asking that the court equitably divide the assets pursuant to the prenuptial agreement. I mean, obviously we objected to the prenuptial agreement, but since the court has found that it is valid, the prenuptial agreement is very specific. And the only other issue I would bring up now is on the equitable distribution worksheet, both Ms. Lanier's and mine, what the prenup says about the IRAs is that they will be split at their present liquidation value if they were to liquidate it and pay all taxes. The amounts on the equitable distribution sheet do not include the taxes. I have those numbers in testimony, that will be in testimony for you, for at least for my clients. And so I would be changing those when we get to that portion. Thank you. And lastly, I know one of the things the court said, two things that the court said at the last trial is it is a shame that they are getting divorced. And I think everybody here would echo that same sentiment. My client has filed for divorce not because of the money. She has filed for divorce because she found Mr. Records 30.
Your Honor, relevancy, we're a no-fault divorce state, and I think she's just trying to prejudice the court at this point.
I will withdraw that. That is fine, as long as it's understood that this is not because of money. The court found that my client.
Your Honor, it's irrelevant.
Thank you, Your Honor.
All right. Okay. Ms. Lanier?
Thank you, Your Honor. I'll try to get right to the point. The husband did file a counter petition on September 2nd, 2020, asking the court to incorporate and enforce the antenuptial agreement, which the court has already held to be valid. I think there's 3 important articles in the prenup that pertain to today's proceedings. The first is Article 3, and we pretty much went through that in great detail in the bifurcation. Article 3 talks about how Ms. Records is to receive a certain percentage of the husband's business, which was auto options, and she did get 9.5% out of the total shares of 500, so she got 47.5 shares. And as the court, I don't know if you remember, but we went over this as well, Mr. Records sold the assets only of the business in December of 2017 for $88,000. He took that $88,000 and put it into a joint account. He subsequently removed $20,000 and paid off business debt, leaving $68,000. That money had been in a joint account. He took the money, he put it in a separate account, and then he put the money back, I think in September of 2018, he put the money back into a joint account. Those funds have been depleted down to $2,700. The $2,700, which is in the account now, is money he's been putting in from his retirement and from his Social Security. There's really no marital money left. I think Ms. Records is going to be making a request for her 9.5% of that $88,000. That's been gone for years. I don't think the court can go back 3 or 4 years and give her money. Your Honor, if you look at Exhibit 30 of the husband's trial book, that's the spreadsheet that we intend to use. And we believe that all the accounts pretty much are marital funds because both of their monies went into it. Both of their names at one time or another were either on the account or money was moved from a joint account to a separate account. The account that the wife has, the money market number 7, that has about $125,000 in it, Ms. Kirby is right. That was from proceeds from the Sinclair property that the parties owned in, or the wife, it was in the wife's name, but they lived in it for, I think, 29 years. And if you recall from the bifurcation proceedings, Ms. Records received the property they owned prior to the marriage per the prenup. It was put into her name after the marriage. She sold that property and they bought this new Sinclair property. At the time they bought the Sinclair property, my client put in half the deposit, she put in half the deposit, and for the next 29 years, he paid the mortgage payments. So when the house sold, per the prenup, that money was theirs. It was put into a joint account. She took the money out of the joint account and put it into her own. Every spreadsheet Ms. Kirby has provided has shown those proceeds should be split. Remember, title is not indicative under this prenup of who gets what. It's how it was acquired. And that's the important part for that. So the corporation, getting back to Article 3, Auto Options Inc. is still a viable corporation. She is still a 9.5% shareholder. Just doesn't have really any assets at this point. The next important article, which is really crucial in this case, is Article 6. And that states, quote, should either party desire to sell, convey, or mortgage any such property, the other party upon request will join in and execute any deed of conveyance, mortgage, or other documents as may be necessary to make same effectual. And I think that's where Ms. Kirby is coming into the house should be joint. And I disagree for a couple of reasons. Number one, there was a 1031 exchange, and the prenup, and we'll get to Article 7 in a minute, but the prenup says if you take one premarital asset and you exchange it for another, it remains your non-marital asset. That's exactly what he did. He could have transferred title to the Mission Drive property to husband and wife, and he never did. It was never his intention to do so.
We stipulated that it had to go in his name.
I understand. I'm saying he could have
Ms. Kirby.
subsequent.
Okay, hold on. We're hearing openings, not argument.
It is she's making argument.
Yes, this is opening statements. Please let me hear her opening statement.
Thank you. Your Honor, when my client took the sale of a commercial property in Ohio and exchanged it for property in Florida, it had to be the same type. It had to be investment property. And so when he transferred it, it had to go into his name because the commercial property in Ohio was in his name. Yes. And he had to keep it that way for 2 years, and they rented it out. And the rental income paid for the mortgage. After 2 years, which would have been 2019, had he wanted and had he intended to gift it to his wife, he would have transferred title. He never did. It was never his intention. And I would disagree with Ms. Kirby when she said that they've amended the prenup. You can't amend the prenup by words alone.
I didn't say that.
She's claiming he gifted it to her. That's not what the prenup says. The prenup says if you own a piece of property before the marriage and you exchange it, it remains your property.
Connor, I'm sorry, but the prenup, it mentions gift. I'm sorry, I just want to.
Miss Kirby,
Yes.
please let Miss Lanier finish without interruption.
Thank you. 1 second, please, Your Honor. Okay. So it does mention gifts from third parties. It doesn't say gifts from each other. I just wanted to clarify that. But moving on to the house, Your Honor. It's our position that the house is his. The acquisition of the cost, $270,000, came from the $270,000 he got from the commercial property. The $280,000 mortgage was because he's been turning it into homestead. The bank required her name to be on the note and mortgage, and per the prenup, she was obligated to do it. It doesn't convert it from a non-marital asset to a marital asset simply by putting her name on the note and mortgage, per the prenup. Now, moving on to the probably the most pertinent article of the prenup is Article 7, and that describes what happens to property the parties had pre-marriage and property they acquire post-marriage in the event of a divorce. So this is a valid contract. The court already found it to be a valid contract, which takes it out of the Ohio Equitable Distribution Statute. There are 7 subparts to Article 7. A through H, there is no G. I just want to note that. So it provides in A that each party keeps the assets they own prior to the marriage. It provides that B, in the case of property acquired during the marriage and paid for by both parties, each would receive their allocable share based upon their contributions to the cost of acquisition. And the cost of acquisition, our argument's going to be, is $270,000. The contributions afterwards are not the cost of acquisition. The cost of acquisition, I gave you Black's Law Dictionary definition, and I also gave you an Ohio State case, that the cost of acquisition is the act of becoming the owner of certain property, the act by which one acquires or procures the property in anything. So the down payment, he became the owner, but the contributions have nothing to do with the future contributions have nothing to do with the actual acquisition. And then in the XREL versus Sherman, Ohio case I gave you, quote, terms refer especially to material possession obtained by any means. And this possession is in the name of, or the possession is in the name of Mr. Record. So it's important to distinguish between the cost of acquisition and subsequent contributions. We do not believe C and D of Article 7 are relevant. Although Ms. Kirby is saying gift, it says gift from third parties. I would assume that would not include the husband and wife, because you don't call husband and wife third parties. E, now this is really important as well, Your Honor. In the case of motor vehicles, the party whose name the motor vehicle is, they keep it. So we would agree that she keeps her car, he keeps his car. The wife's argument that, we could call it a trailer, a mobile home, a manufactured home, her argument is under Ohio law, it's a motor vehicle. The definition of motor vehicle is very important, and Your Honor, I have provided you with case law, and I disagree with Ms. Kirby. None of the cases require the title to be part of the land, to be part of the the trailer to become part of the property. All the cases provided by Ms. Kirby, none of them have say that the wheels were taken off. Well, hold on, Aaron, I'll tell you. The Ohio law clearly distinguishes between the description of the property at the time it's manufactured, and the definition must be based on how it currently exists. And I believe the case law is going to show that it can change from a vehicle to a structure because it has no wheels, it has no axles, it has no hitch, and it is connected to utilities. It's not self-contained. Ohio law requires the transfer of the title. Ohio law does not require the transfer of the title in order for it to lose its motor vehicle status. And I can argue that at the end, Your Honor, but I just want you to be aware that it doesn't have the indicia of a motor vehicle anymore. It is tied to the property. It has no motor. And you have to first look at the definition of vehicle, and then you look under the definition of motor vehicle. And it has no motor. It's not self-contained. It doesn't have its own waste disposal. It's hooked up to city sewer and water. So, Your Honor, we believe that it's been taken out of the vehicle status, and it is a marital asset because it was bought with proceeds from assets that were acquired jointly. So, moving on. H of Article 7 says, in the case of any other substantial asset acquired during the marriage, which could be the house, to the extent the cost of acquisition can be traced to property owned by him or her immediately prior to the marriage, then they get to keep the property. And that's the 1031 exchange, Your Honor. So we believe the Mission Drive property, we're arguing, is 100% asset of the husband because he acquired it through assets owned prior to the marriage. And he only asked her to sign the note and mortgage per Article 6 because the bank required it. We believe the manufactured home is also a marital asset because it was acquired with funds that they both earned during the marriage, and it has lost its motor vehicle status. There is also a Regions escrow account, Your Honor, in Irma, the husband and wife, because they are the insured, received a check for about $80,000. They put a new roof on the property, leaving a balance of $41,000. We believe that's the husband's. The retirement is to be split. I think that it's the date of distribution is the important date, and not today, because they're both entitled to the growth or the losses until they're split. I think Ms. Kirby and I can work that out. We could figure out what the value is on the date they're to be distributed. That should not be a problem, and it should not be today's date. The value date is the date of distribution, so they each get the gains or the losses equally. There is a diamond ring that was purchased during the marriage. It's worth about $11,000. It was bought with marital funds. That is, under the prenup, it's a marital asset. And so we think the court should divide that asset, or at least put it on the spreadsheet. As far as the furniture and furnishings, the wife had made a list of items that she wanted out of the marital home. She has a fully furnished home. My client wasn't asking for anything out of that other than his gun, but if we can work that out, there's about five or six items on the list she wants to take out of the house that my client disagrees with. I gave that list to Ms. Kirby yesterday. I haven't heard back, but I think in a break we can work that out. As far as alimony, the wife makes more money than the husband. Her Social Security is about $16.25 a month. My client's is $12.25. He does receive rental income currently, but that goes to help pay for the mortgage because he doesn't have enough money to pay for the mortgage. And the wife, in her retirement, was receiving $400 a month from her annuity, and she cut that off. Don't know why she cut it off, but she cut it off, but she can get the $400 a month. So that leaves her with $2,000 a month, and my client $1,225. So I don't know where she's coming up with the alimony, but that's all we have, Your Honor.
Okay. Just so we can figure out housekeeping before we proceed, do either of you expect any other witnesses besides the parties?
I don't.
Only if, in rebuttal if necessary. Hopefully not.
Okay. And it sounds like, just from hearing openings, that a lot of what we're talking about here is questions of law versus questions of fact.
Some of it is a question of fact, Your Honor.
There is some questions of fact? Okay. All right. Is there anything else that we need to discuss from a housekeeping perspective before we proceed today? Ms. Kirby?
Just stipulation on the, I don't think so. We already talked about the stipulation on the 1031 exchange.
Your Honor, if she's saying it was stipulated that he put the property in his name, if you recall,
I didn't
that isn't.
I didn't hear what she said, just stipulation.
That we stipulated that when he bought the house on Mission Drive, I understand you dispute that it was to be her house, but even if it had been, it had to have gone in his name pursuant to the 1031 exchange rules. We stipulated to that last time. I was going to call Jack Brugger and you said I didn't need to.
That's true, but that's not the only reason it went into his name, even if it didn't have to.
But it had to because of the 1031 rules, and we stipulated to that.
Okay. All right. Ms. Lanier, is there anything from a housekeeping perspective that we need to discuss?
No, sir.
All right. Before we proceed to evidence, I just want to take 5 minutes. I'll be right back.
Yeah.
Thank you all very much for your patience. I felt the need to refamiliarize myself with the anti-nuptial agreement before we began testimony today. Ms. Kirby, please call your first witness.
Call Richard Records.
Okay. Mr. Records, please raise your right hand and be sworn in by the court.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. I know who you are, but just for the record, can you please state your name and date of birth for the record?
Richard Allen Records, March 26, 1948.
Okay. Please proceed, Ms. Kirby.
Good morning, Mr. Records. Could you turn, I provided your attorney with a book of exhibits. Could you turn page, I'm sorry, to the tab marked 2.
I'm sorry, I didn't hear that.
Marked tab 2.
Tab 2.
Okay.
Do you recognize that document?
Yes.
What is that?
It's our prenup or antenuptial agreement.
Okay. And are you asking that the court enforce that antenuptial agreement?
Yes.
Is that a true and accurate copy of the antenuptial agreement?
Yes.
Your Honor, I would ask that it be admitted as exhibit, as exhibit 2.
Any objection, obviously?
Well, no objection, Your Honor, but I was thinking that all the exhibits that were already marked to put into evidence at the bifurcation would remain in evidence. Do we have to?
I would think so too, but I think it might end up being difficult today to go back and forth. So I guess unless the parties have an issue with it, I mean, this was entered into evidence. Obviously, I'm going to admit it into evidence. I guess it's just a question of numbering.
Right, Your Honor, my numbering, the clerk already kept them because I just did one notebook. And so the clerk has my numbering. It's going to be the same as it is in my trial book today.
Your Honor, I think this just makes it cleaner.
Okay, let's go with Ms. Kirby's exhibit for now.
Okay.
We may get duplicates entered into evidence, but that's not necessarily a terrible thing.
Okay.
Exhibit 2 is admitted.
Mr. Records, can you look at the tab marked 8, tab 8, please?
Yes.
Do you know what that is? Recognize that?
It's a check written to Mark Ketchum trust account for $5,000 on April 7th, it looks like, 2016. And it's identified as a mission deposit.
Is that your understanding that that was the check to put the deposit down on Mission Drive?
Yes.
Your Honor, to ask to admit Exhibit 8.
Any objection?
No.
Exhibit 8 is admitted.
And where did that check come from? What account?
It came from a joint Fifth Third account ending in 1337, it looks like.
And who, what do you say, joint account? That's joint with you and Mrs. Record?
Yes.
And who is it signed by?
Sharon Records.
How did you go about the process of purchasing Mission Drive? How did you find Mission Drive?
We worked with a realtor. We looked at properties all over Southwest Florida, as far north as Fort Myers, actually. And I liked Monterey. I liked the community.
Who did the majority of searching?
Objection, relevancy.
What is the relevance, Ms. Kirby?
Your Honor, the issue is whether it was a gift or whether it was their joint property. And I think all of this goes into that. And I have case law that I can provide for you, Your Honor, if you'd like.
Well,
Okay, hold on. You have case law that says the fact that she was involved in searching for the property
Yes, I do.
in the face of an anti-nuptial agreement?
Yes, Your Honor, I do.
Okay, all right, proceed.
Ron, may I just, for the record, state my objection more clearly? According to Article 7, which is how the property is to be distributed, there's no mention of a gift from one spouse to another. It's strictly upon allocable shares and or whether it was a premarital asset or asset or, paid for by their income. There's no provision for a gift from one spouse to another.
Okay, we'll have to save that for argument. The objection was to relevance. At this point in time, I can't rule that it's not relevant, or it may not be relevant, but at this point in time, I'm not sure.
Mr. Rickards, I'm going to come back to that line of questioning in a moment. Can I ask you to go back to Exhibit 2?
I guess both parties should probably just have the prenup out and ready for the duration of this trial.
okay.
And can I ask you to go to page 3 of Exhibit 2?
Yes.
And can I ask you to look at Article 10 of Exhibit 2?
Yes.
Now, the document speaks for itself. Would you agree?
Yes.
And would you agree that the document says Richard and Sharon understand during their lifetime or by testamentary disposition, they shall have the right to make gifts to their respective families and to anyone else, including one another, at any time? Do you agree that it says that in your?
Yes.
So would you agree that you can give a gift pursuant to each spouse pursuant to the prenuptial agreement?
Yes.
All right. So I'd ask you to go back to Exhibit 8, please. And to your knowledge, is this the check from the joint account written by Mrs. Records that paid for the deposit on Mission Drive?
Yes.
And back to the question, that was objected to, who took primary lead on finding the house on Mission Drive?
I was probably back in Ohio most of the time we were looking for a property. On a 1031 exchange, we had to identify a property. So I couldn't leave the business at that time. So she wanted to be down in Florida. She came down to Florida and she was looking for property. And when I had time and I could afford to get away from the business, I would fly down and we would look at a select group of properties with the realtor. So she probably looked at more properties than I did.
Can I ask you to turn to, I'm sorry. And so when you decided on Mission Drive, what was the cost of Mission Drive?
$550.
And what was the amount that you were able to put in through the 1031 exchange?
$270,000.
And how did you afford the rest of the cost of Mission Drive?
Borrowed it from Flagstar Bank.
Who borrowed it?
We did.
Okay. So I'm going to ask you to go back to page 2 of Exhibit 2. Page 2 of Exhibit 2.
Okay.
Okay, I'm going to ask you to look at Article 7,
Okay.
Paragraph B.
Paragraph B. All right. Okay. Wait a
Would
minute.
you agree that Mission Drive was acquired after the marriage?
I'm sorry, did you say Article 7, paragraph B as in boy?
I'm sorry, Paragraph A, subparagraph B, Section B.
Section B pertaining to alimony? Is that where?
No, in paragraph A, there
Yeah.
are sub-paragraphs, or there's sub-sentences. Sentence B.
Okay.
The case of the property acquired by the purchase after the marriage. That sentence.
Okay. And paid for by both parties, his or her allocable share thereof, based on the parties' respective contribution to the cost of acquisition. Do you see that?
Not exactly, but I'm listening to you. Go ahead.
Okay. And would you agree that you could not have bought Mission Drive with just the money from your 1031 exchange?
Right.
And you had to get a mortgage?
Right. I had to get a mortgage.
And that deposit was for the down payment on the house?
No, I believe it was actually used to cover closing costs on the house.
Let's look at go back to 8. What is the date of that check?
Exhibit 8.
I believe it's April 7th of 2016.
And when did you purchase Mission Drive?
I don't know.
Okay.
Maybe May 16th of 16.
Okay. And now I would ask you to go to tab 9.
Okay.
And do you recognize that document?
I don't know. No, not really. I don't.
Okay, that's fine. I'm going to ask you to go to tab 10.
What was it for? When was it dated?
Go to 10.
All right. All right.
All right. And do you recognize that document?
Yes.
And what is that document?
It's a statement of mortgage.
Okay. And on that document, if you look, whose name is on that? It's the statement of mortgage for the house on Mission Drive.
Yes.
And is that a true and accurate copy of the mortgage statement?
Yes.
Your Honor, I'm going to ask that, hold on one second. I think there might I'm going to ask that the first 3 pages, oh no, I'm going to ask that that be admitted as Exhibit 10.
Any objection?
If this is a complete document, if it's a complete document, I have no objection. Ms. Kirby, is that the complete document?
Yes.
Yes, I have no objection, Your Honor.
Yeah, Exhibit 10 is admitted.
And if you look on the second column, there's kind of 2 columns. One of them says account information.
Yes.
And do you see where it says restricted escrow balance, $84,455.02?
Yes.
What is that?
That is money that was given to cover a damage from Hurricane Irma.
Okay. And I'll come back to that. I'm going to ask you to look at tab 11.
Okay.
And do you recognize that document?
Yes.
What is that?
It's a note for the Mission Drive property.
And who are the owners? What parties owe money on the note?
It is signed by Richard A. Records and Sharon L. Records.
So you would agree that Mrs. Records is liable for the mortgage on Mission Drive?
Technically, if I don't pay it, yes.
What do you mean by technically? You mean the bank would not come after her?
Oh no, the bank would come after her if I don't make the payments, yes.
And she's on there as a primary obligor, correct? Your Honor, I don't think the lawyer's allowed to help.
I'm looking at I haven't opened my mouth. I'm looking at the document.
Okay.
May I look at the document, Your Honor?
You may.
Thank you.
I'm sorry. The question is, I'm sorry. Can you just ask me again?
Is Miss Records a primary obligor on the note?
I don't know. I guess I don't know.
I'm going to ask you to turn to tab 12.
Okay.
Do you recognize that document?
Yes.
What is that document?
It's homeowner's insurance policy. Cover page.
All right. And what is it insured? What is it insurance for?
Homeowner's insurance for the house on Mission Drive.
Your Honor, I'd ask that the court admit Exhibit 12.
Any objection?
No, sir.
Ms. Kirby, did you seek to admit Exhibit 11? I don't know if you were meaning to.
Oh, I'm sorry. I would ask to admit Exhibit, I think you said, yeah, Exhibit 11.
Ms. Lanier, any objection to Exhibit 11 being admitted?
No, sir.
Exhibit 11 is admitted.
And I apologize. I'm going to back up a minute. Can you go back to correct?
Yes.
And who are the names to correct?
Yes.
And who are the names to who the mortgage statement is addressed?
Richard A. Records, Sharon L. Records.
You can go back to Exhibit 12.
Okay.
So you would agree that the insurance policy for Mission Drive is held by Mrs. Records and by yourself, correct?
Yes.
I would ask you to go to Exhibit 13.
Okay.
You recognize this document.
Yes.
Now, it is a number of pages, so I'm going to go through it. Do you recognize the first page?
Yes.
And then you probably don't recognize the second page. It's my motion for judicial notice. But I would ask you to turn to the following page, complaint for damages. Do you see that?
Yes.
Do you recognize that document?
Yes.
Okay, what is that?
It is a complaint that I believe our attorneys filed on our behalf against the insurance company because they wouldn't pay.
Okay. Now, is that what resulted in the $81,000 on the mortgage statement in the restricted account? Or 80, whatever it was, 84?
Yes.
Okay. So, Your Honor, I'd ask the court to take, I probably made a mistake here. I would ask the court to take judicial notice of the lawsuit. I had previously filed a motion, and I would ask the court to admit Exhibit 12, which would really, I have the whole thing in there, but would really just be the first page.
Any objection, Ms. Lanier?
Did you say Exhibit 12?
13.
13.
So the first page I have of Exhibit 13 is the Cassell and Cassell attorneys at law.
That would be the only thing. The others is, I asked the court to take judicial notice of the other, but.
So the second page is just the request to take judicial notice. It's really
So
kind of
first,
I could
out of order.
deposit exhibit, or I could, however the court prefers. If it's easier to have it together, or.
It's fine to have it together, but the question is, Ms. Lanier, is there any objection?
to the first page of Exhibit 13, no. To the request for judicial notice, no.
Okay. Well, is all Exhibit 13? Is there any objection to? Are you only seeking the first page of Exhibit 13, Ms.
The whole
Record?
thing, if I could just do it together, I think it'd be.
Yeah. Is there any objection to Exhibit 13?
No, sir.
All right, Exhibit 13 is admitted.
If you turn now to, I guess it would be about page 5 of Exhibit 13. It says page 2 of 5 at the bottom.
Right. I got it.
And do you see paragraph 3?
Yes.
Okay. And this is a lawsuit that you filed, correct?
Yes.
And you are the petitioner, or the plaintiff, and Mrs. Records is the plaintiff, correct?
Yes.
And in paragraph 3, it says that you and Mrs. Records are the owners of the property, correct? On Mission Drive.
Yes.
Would you agree that that's what it says?
Yes.
Let's go back to the first page, the Cassell and Cassell page.
Yes.
And would you agree that both you and Mrs. Records signed the settlement agreement for that lawsuit?
Yes.
And you wrote in there, Sharon took $5,000.
Yes.
All right. And you took $5,000 as well, correct?
Where are you? This is still part of.
Exhibit 13.
Let me say the only way I could give my 5 was to give her 5.
Hold on. There's a settlement agreement as part of 13. I haven't gotten there yet.
Sorry, it's a closing statement. I'm sorry, it's just a close. I called it a settlement statement, but it's a closing statement for their lawsuit.
What page is this in 13?
It is the first page of 13.
First page of 13. Okay. Okay. Sorry. Now I'm there. I was having trouble following.
Okay. Now, can you turn to Exhibit 21? I'm sorry, tab 21.
Yes.
Now, one moment, you're on. Do you and Mrs. Records have text accounts? Do you text each other?
Yes.
And have you and Mrs. Records sent texts to each other?
Yes.
Is it not true that you told Mrs. Records on about November 9th, 2020, everything was the two of yours? Everything was ours.
I don't recall. Am I supposed to be looking at a document that says that?
I'm asking you a question, but I'm just asking you if you recall saying that.
Repeat the statement.
Did you text to Mrs. Records, it was all ours, but you wanted to know what you could get in a divorce?
Where are you?
I'm not anywhere on the document. I'm asking him if he recalls texting Mrs. Records, it was all ours, but
Okay.
you wanted to know what you could get in a divorce.
No, I don't recall that. But
Would it refresh your recollection to review a printout of the texts between you and Mrs. Records?
that would be helpful, yes.
I'm going to ask you to review the first page of the document behind Exhibit 21.
I'm there, I believe.
And do you recall that text exchange between yourself and Mrs. Records?
I suppose so. I mean, I don't recall it, but it's possible I did it. I probably did it, so okay.
And so you told her it was all ours.
Where are you looking?
I don't see this.
I don't either.
I'm going to object if she's trying to introduce this into evidence.
I'm
Your
not
Honor.
introducing it to evidence. I asked if it would refresh his recollection, and he just
Objection sustained.
would it refresh your recollection? Did you review the page?
Page 1 of 1, right?
Yes.
All right. This is about me driving through the neighborhood, right?
And do you recall the conversation where Mrs. Records said, I thought everything was ours, but now we need to divide it up and let the courts decide? And do you,
Okay, I see it. I see it now.
do you recall that conversation?
Yes.
And do you recall telling Mrs. Records it was all ours, but you wanted to know what you can get in a divorce? It was no one else's, it was ours.
I'm objecting if she's reading from a document and asking
Asking
him.
if you recall telling her that.
I'm sorry, what's the basis of the objection, Ms. Lanier?
Predicate, hearsay.
Not hearsay. Those objections are overruled.
It's a question to me, right?
Yes.
What's the question?
Do you now recall telling Mrs. Records it was ours, it was all ours?
Okay.
Yes, but may I expound upon that a moment?
The question I asked was,
Just answer her question, and you'll have an opportunity on cross-examination.
Okay.
To the extent you would like to expound on it.
I'm going to ask you to turn to Exhibit 17. I mean, tab 17.
I'm there.
Do you recognize that document?
Non-lawyer disclosure. Is that what I'm looking at?
Do you recognize it? That's all I asked.
No, I don't know. But
I'm going to ask you to turn to 18. Tab 18.
okay.
Do you recognize that document?
Yes,
What is that?
it's a lease agreement with a tenant, Cheryl Malik and Michael Beltran, that we leased the property to.
And who does it reflect the owners of the property are according? Oh, I'm sorry. I would ask to admit that as Exhibit 18.
Any objection to Exhibit 18 being admitted?
Please, Your Honor. I do, Your Honor. My client didn't sign this document, so I'm not sure that he can authenticate it.
Said he recognized it.
It's not a document that he's a signer on.
Would you care to build more of a foundation?
Did you?
I'm not going to admit it at this time, but Ms. Kirby, please proceed.
Did you rent the house on Mission Drive to the people in that lease?
Yes.
And how did you go about getting those renters?
Sharon was acting as an agent and acquired those tenants.
And was it usually Sharon who got the tenants for the,
Yes.
and she signed the lease?
Yes.
And did you ever look at the lease?
I think it's standard Board of Realtors lease for Florida, so I'm somewhat familiar with it, yes.
Okay. And would you have known that it says that the owner has to sign the lease?
I don't exactly see that, but I would expect the owner would have to sign the lease, yes.
Okay. And did you sign the lease?
No.
So would it be reasonable to think that the owner would sign the lease?
Or an agent for the owner, yes.
And if they were an agent for the owner, would they put that they were an agent for the owner?
I don't know.
Would they get paid as an agent for the owner?
Yes.
Did you pay Mrs. Rickards anything for this?
No, not specifically, no.
Your Honor, I would ask to admit Exhibit 18.
Any objection, Ms. Lanier?
Objection, authentication.
Overruled. Exhibit 18 is admitted.
And would you agree that Mrs. Rickards signed the lease as owner of Mission Drive?
Yes.
I'm going to ask you to look at Exhibit 19. I mean, tab 19.
Got it.
Do you recognize this document?
Yes.
What is it?
It's a check that was written to me on December 7th of 2020.
From who?
Ashley McConnell.
And who is Ashley McConnell?
She's a friend that needed a place to stay. I let her stay there briefly, and she wrote this check to kind of provision the house. She wanted certain food, certain things there. So I cashed it for her, and she took it and bought things.
I'm sorry.
Okay.
You cashed a check for her?
Yes.
Right. And how long did she stay in the house?
Oh, probably 6 weeks.
Did she pay rent?
Over and above this 800, if you construe that as rent. No.
Can you clarify? I'm sorry. I'm going to come back to that question. Can you turn to the second page?
Yes.
And do you recognize those two checks?
Yes.
What are they?
Checks that a friend of ours from Ohio wrote us for staying at our place.
Your Honor, I would ask to admit exhibit 19.
Any objection, Ms. Lanier?
No, sir.
Exhibits 19 are admitted.
I'm sorry. Now I'm going to go back to what's her name? Ashley, Miss McConnell. I'm sorry. I would ask you to clarify what I didn't understand what you said. Did you say she cashed the check, I gave it back, but also it was rent?
Yes, I guess that's accurate. Yeah, she wanted to contribute to the household, so she wrote a check to me. I cashed it. She went to the store. She bought things for the house in lieu of rent, or whatever you want to call it. Yeah,
What did she
exactly.
buy?
Pardon me?
What did she buy?
Food, primarily, dishwashing, soap. She didn't spend it all at once. It was over the period of time she stayed there.
Have you had any other renters in Mission Drive?
Yes,
What other renters have you had?
his name is Alan Tett, T-E-T-T.
And how much does he pay for rent?
$7.25 a month.
And how much, who lives there now?
He does.
Okay, anybody else?
Just me.
And where do you put the money that he pays you? Oh, what does he pay you in rent? $7.25?
Yes.
And where do you put that money?
In a drawer. So, I pay the lawn care people. I pay, I have a lady that cleans. I pay her. And I buy groceries and things with it too.
And when you and Mrs. Records purchased Mission Drive, how did you pay the mortgage?
Automatic withdrawal out of a checking account.
Which checking account?
I believe it was Fifth Third.
Is it that same 9337 that was a joint account?
Yes.
Okay. And what money went into that account?
The money from the tenant, as well as money that I earned in rent from the building that Auto Options was in.
What about after you sold Auto Options?
Then it still came out of that account until probably, I don't know, November of 18. And then it came out of the Chase account, which is 0818.
What other money went into 9337?
At what point? I mean, at what time frame?
That time when the rent was being paid, the mortgage was being paid?
Money out of my IRA, my Social Security, I suppose. That was the primary account that we lived on.
Okay, I'm going to ask you to turn to tab 15.
Okay.
Now, Your Honor, I tried to, so it'd be easier, I tried to send over Bates stamped copies. I don't know if you got them. It
I
should
did
be.
not get Bates stamped copies of
It
this?
came in yesterday.
Oh, wait, let me see.
I think it was this morning dropped off
No,
according
no, I dropped
No.
them off him yesterday for you this morning. Because I thought I
You
could
know
see
what?
that.
I did just get this brought to me. So this is, I got replacements for exhibit 15 and 16.
Here, look at the 15.
Stamp.
It's stamped down here.
Okay.
Do you recognize these bank statements?
I guess, yes. I mean, I didn't.
Are they,
I didn't. Go
Are they the bank statements for your joint account at Fifth Third ending in 9337?
Yes.
And I'm going to ask you to look at page 2. I'm sorry. Yeah, page 2.
Okay.
It says trial 2 at the bottom also. Do you see a deposit into that account? Mass Mutual,
It's the top of the page.
Yes, I see it.
and that is the account that your attorney talked about that was Mrs. Records Mass Mutual annuity.
Yes. Yes.
I'm going to ask you to go to page 4.
Page 4.
Yes.
Getting there.
It's called trial 4.
Where are you going?
If you look bottom middle.
All right.
You gotta look down here.
I see.
I'm just showing them how to get there.
I got it.
And do you see the deposits in there? SSA Treasury 1549
Yes.
for January 20th and February 17th.
Yes.
Those are Mrs. Records Social Security deposits, correct?
Yes.
You do not see any deposit for your Social Security in there, do you?
No, I don't, but I do see a. No, I don't.
And you see on 2/9, you see a withdrawal for 1871.
Okay.
Is that for the mortgage payment?
I don't know.
Okay,
It says Chase.
okay,
No, I was probably for a credit card.
okay. I'm gonna ask you to turn to trial 6.
Okay.
And do you see a deposit in there of 1549?
Yes.
Do you see your Social Security going into that account?
No.
Now I'm gonna ask you to go to, one moment.
Let's see.
Trial 25.
Huh?
I'm sorry, Lisa, what did you say?
Trial 25.
Okay.
Oh, trial 25, not exhibit 25.
Sorry.
My bad.
All right, tell me when you're there. Are you there?
Yes, I am.
Can you look at, I'm sorry, trial 26. Next page.
Okay.
Do you see your Social Security money going in to that account as a deposit?
No.
Do you see Mrs. Records IRA money going into there as a deposit?
Yes.
Do you know what that $3,800 is?
I'm assuming it's rent
Okay.
from our tenants.
All right, I'm going to ask you to go to, hold on. I'm sorry, I'm going to ask you to go to exhibit, I'm sorry, tab. I'm going to ask you to go to tab 14.
Okay.
Do you recognize that statement? I'm sorry, did I have, that was admitted, correct?
What?
Or 15?
It hasn't been offered yet.
You're going to ask that exhibit 15 be admitted?
Any objection, Ms. Lanier?
No, sir.
Exhibit 15 is admitted.
And 14, do you recognize that document?
Yes.
And if you could turn to the second page. Do you see that, is that where your Social Security?
Yes.
Okay. So where was, which account was the mortgage paid from? The Chase or the Fifth Third?
At this point, Chase.
Okay. I'm gonna ask you to go back. I'm gonna ask you to go back to exhibit 15.
Okay.
And I'm going to ask you to turn to,
Are you on exhibit 15 or use this one? Ready to stand.
Ms. Kirby, were you seeking to admit exhibit 14?
I can, yes.
I just wanted to make sure you did.
Yes, I would like to put in exhibit 14.
Ms. Lanier, any objection to exhibit 14?
No, sir.
Exhibit 14 is admitted.
Okay, just one moment. What is the, I would ask you to turn back to exhibit, I'm sorry, 15. And if you could go to trial 52.
Okay.
Do you see the debit for 1492.76?
Yes.
Is that the mortgage payment? I'm sorry. It was 2431.09, right above that.
I see it.
Yes. Is that the mortgage payment?
Yes.
So would you agree that when you bought the house, the mortgage payment was being paid from the account that Mrs. Recker's Social Security went into?
Yes.
And there came a point when she moved out and she no longer paid the mortgage, correct?
Those were not simultaneous. She quit paying the mortgage, and as you can see in this, it would have been, if you go back to the change.
Mr. Records, there came a time where I'll withdraw the question. There came a time when she stopped paying the mortgage.
That's correct.
Why would Mrs. Records pay a mortgage for the house that you're saying wasn't hers?
We were married. I mean, we paid a lot of each other's bills.
So you were like partners in everything.
Some things, yes.
And so it wouldn't have been unreasonable for her to think that you were buying the house when she put her name on the mortgage. She found the renters, she paid the mortgage. for her Social Security funds?
Yes.
And when you said it's all ours,
You know, you asked me if I have a roommate, and his name is Alan Tett.
I'd ask
Mr. Records, I don't, doesn't appear that this is approaching an answer
Okay.
question, but it may be, but please just refrain from anything extraneous and answer Ms. Kirby's questions.
Okay. I'm sorry, the
Is
question?
there a question pending?
No, Your Honor, I'm sorry.
Okay.
One moment. Now, when Mrs. Records stopped paying the mortgage, how did you pay the mortgage?
My Social Security, my IRA, and cash that I had from the sale of auto options.
What did you do with the money from the renters?
I wasn't, there were no tenants in there at that time, I don't believe.
But how long has Mr. Ted lived there?
He moved in December of 20. Wait a minute. December of 19, I guess. So he was there the entire year of 20 and in these few months of 21. Okay.
All right. And what other renters did you have besides Mr. Tet and the people with those checks and Miss?
None.
And so how does Mr. Tet pay you?
Cash.
And what do you do with the cash?
I put it in a drawer. I told you I use it for other people I pay in cash.
Why did you pick Mission Drive?
I liked it. I liked Monterey.
Okay. Would you agree that the Sinclair house was Mrs. Records' house?
No, it was our house. I paid on it for 29 years.
Out of what account? A joint account
Yes.
that Mrs. Records' income went into and that your income went into?
Well, mine went into it and her Social Security. Yeah.
And she worked at the shop and didn't take pay, correct?
No, that's not correct.
And the deed to Sinclair was in Mrs. Records' name.
That's correct.
And you paid for Sinclair from the Olentangy house, correct?
Part of it. The down payment, part of it, yeah.
Okay. Which was Mrs. Records' premarital property,
Yes.
but you're considering it your home
Not that home, Sinclair.
that was paid for with Olentangy.
No, it wasn't really paid for with Olentangy. Matter of fact, I took out a loan against my business. I think it was about $100,000 refinanced, and we were going to improve Sinclair, and we were going to put about $80,000 into a renovation out of that money I borrowed, but we wound up not being able to afford that, so we made about a $40,000 renovation to Sinclair out of the money I borrowed. So,
But $70,000 of Olentangy went into Sinclair when she sold Olentangy, correct?
I don't know.
And you consider it your property because you paid on the mortgage?
Correct.
even though the deed wasn't in your name.
Right.
Okay. And do you think that Mrs. Records is entitled to reimbursement for the money she put into what you consider a joint house from her premarital property?
Well, we should have split the property evenly. When we sold it for $188,000, we each should have got half of that. Because it was obviously marital property.
Even though it's exchanged from Olentangy.
I don't recall whether it was exchanged. I mean,
But your attorney said that in opening.
I'm sure we put money from Olentangy into that house.
Like you put money from Garden into Mission Drive.
Yeah, well, no, not at all. No. It was not a 1031 exchange of any kind.
Mrs. Sinclair, Mrs. Records owned other property when you got married, correct? She owned Miramar. Condo,
Yes. Yes.
And then she did a 1031 exchange for a house on Stormcroft.
Yes.
And then she sold that Stormcroft house, correct?
Yes.
And she put that Stormcroft money into a joint account, correct?
Yes, I suppose.
So all of her money from her premarital money went into what you consider joint property, correct?
Yes.
But your money that from Garden, you're saying is only yours. Is that correct?
Yes, that's correct.
So she was very generous with her premarital money.
I wouldn't say so.
Do you believe that she should be reimbursed for the premarital money she put into Sinclair, which is now in the Capital One account?
As I stated, no, I think all the proceeds from Sinclair should have been split 50-50. I paid on the mortgage for 29 years.
From a joint account that her social
Yeah.
security went into also?
Yes.
So it was only you? Is that what you're saying?
I was earning a lot more money than she was.
The records, you had spoken with Mrs. Records about getting an appraisal on her trailer. Do you recall that?
I'm sorry?
You had spoken with Mrs. Records about getting an appraisal on her trailer? Do you
Yes.
recall? Why did you cancel that?
Objection, relevancy.
Overruled for now.
I did.
Yeah.
They would not do the appraisal because I was required to list them as a witness. They were out of Michigan, and they did not want to get involved if they were going to be called as a witness.
Okay.
They wouldn't do it. They were afraid of the liability.
Mr. Records, in opening, your attorney talked about a ring.
Yes.
All that worth, I don't know what she said, around 10,000 something?
Yeah, I think we submitted an appraisal on it.
And that is before you got married, you bought Mrs. Records an engagement ring, correct?
Yes.
And that ring got lost.
Yes.
And the ring that you were talking about was the replacement ring, the replacement ring for her engagement ring, correct?
It was another ring, yes.
It was the replacement for her engagement ring?
Yes,
And you received insurance money for that lost ring?
yes.
And how much did you pay for the ring?
The first ring or the second ring?
The first ring?
$5,000.
And how much did you pay for the second ring?
I'm not sure. She purchased it.
As
I
a
don't-
replacement for the engagement ring that you had bought her before the marriage?
Yes,
That was lost and paid for with insurance money?
yes.
Now,
Well,
if the court finds that that ring is marital, are you agreeable to taking the ring and putting the $10,995 in your column as the distribution?
Wait, can you repeat that question?
If the court finds that that is marital property, are you willing to take the ring and put the $10,995 you have listed on your equitable spreadsheet as the marital value for her? Are you willing to pay $10,995 for the ring?
Is this that doesn't seem like a question of fact. It seems more like a negotiation. Where
Right, I object, Your Honor. The court's gonna make the ruling on that.
If the ring was yours, would you agree that it was worth $10,995?
I don't know.
Okay.
Mr. Records, Tuesday, we received a new spreadsheet in which you are now claiming for the first time on Tuesday that the money market account that Mrs. Records inherited from her father is marital. Why do you believe it is marital?
Objection, Your Honor.
What's the basis of the objection?
That's a legal conclusion.
Sustained.
Would you agree that Mrs. Records received an inheritance from her father?
Yes,
And would you agree that Mrs. Records had to use some of that to help you guys over a tough time when you did not have money?
yes,
And would you agree that Mrs. Records was entitled to be paid back when she paid bills for auto options when you didn't have money?
no,
You do not believe that let me clarify. Do you agree that Mrs. Records paid auto options bills with money she took from her father's account?
no,
Do you agree that during part of the year that you were trying to sell auto options, you would pay business debts from your joint auto option debts from your joint Fifth Third account to
Yes.
maximize, I'm sorry.
yes,
And do you agree that Mrs. Records paid bills from the joint account that were those auto option bills?
yes,
And for clarification, because not everybody knows, auto options is a business that you claim primarily as yours. I think 91.5%.
90.5, yes.
90.5%. All right. And how long did you pay auto options bills from your personal account?
I don't know, a few months.
If I said 3 years, would you disagree?
Yes,
Do you agree that Mrs. Records' father gave her some gold coins?
yes.
How many gold coins do you believe he gave her?
I don't know. I know we bought some coins from him as well.
Have you put any money into any Fifth Third checking account since this petition was filed? Petition for divorce was filed.
I believe I made one deposit.
To which account?
The Fifth Third you're talking about, 9337.
I'm looking at your spreadsheet from Thursday, June 15th.
Okay.
I guess for exhibit
30.
30. Now, you have listed on your exhibit at line 5, checking a Fifth Third checking 9485 as marital, and the amount of 7,214.
Yes.
Are you claiming that is marital?
Yes.
Did you put any money in there?
No.
Do you know when she opened it?
No.
At line 1, you're saying you're chase checking 0818. Do you see that?
I don't understand. Hold on a second. Didn't he just testify that he did put money into it?
He said he did not.
Not that account.
He
Okay.
9337.
Okay.
1. Joy chase checking 0818.
Right.
And you have on your equitable distribution sheet that is a joint account, correct?
Yes.
And you have that is your non-marital property, correct?
I don't know. Does that mean it's not there?
I can't answer.
Oh, I'm sorry. It's listed there as item 1. Does that mean it's not
Well,
there?
why don't you ask him fact questions rather than legal conclusions?
I am going to ask you to go back to the book, my book. And I am going to ask you to turn to exhibit 36.
All right.
What is that? Do you recognize that?
Yes.
What is that?
It's a withdrawal from Chase, September 30th of 19.
And do you still have that money?
No, I mean, no, it's
I'm
gone.
going to ask that exhibit 36 be admitted.
Any objection?
Irrelevancy.
What is the relevancy of this, Miss Kirby?
Marital equitable distribution, Your Honor. I'll have further questions.
The funds, he just testified the funds aren't there. Are the funds, how can I equitably distribute something that's not here?
All right, Mr. Records, did you?
I don't mean to be,
That's fine. I'll withdraw that question. I'll ask other questions first.
okay.
Mr. Records, you withdrew that money when Mrs. Records said she wanted to get divorced, correct?
Yeah. Yeah.
And what did you do with that money?
Put in safe deposit box.
And where is it now?
Well, I spent it.
Do you have any left?
15,000.
What did you spend it on?
Paying the mortgage and living in the house.
You previously testified that you paid the mortgage from Social Security, the IRA, and the cash from the renters.
Yes.
So also you paid it with this?
Yes.
And that was from a marital joint account.
Yes.
And could you turn to page, I'm sorry, Your Honor, I would ask to admit Exhibit 36. It goes to, I think there was some indication that he paid all the mortgages, and that was from a joint account.
Any objection, Ms. Lanier?
Still relevancy, Your Honor.
Exhibit 36, I'm going to overrule the objection. Exhibit 36 will be admitted.
Do you recognize this check? This withdrawal? I'm sorry, 37. Could you turn to 37, please?
Yes.
You recognize this?
Yes.
What is it?
It's $5,000 check
To who?
to me.
Is that $5,000 check from the settlement, Cassell's settlement proceeds?
I don't know. Could be. I don't know. Yes, it is, I think. It's coming out of Fifth Third, yes.
And I would, Fifth Third, you took it out of Fifth Third?
Yes.
9337, the joint account
Yes.
that Mrs. Record's Social Security money goes into?
Yes.
Your Honor, I would ask to admit that as Exhibit 37.
Any objection?
No.
Exhibit 37 is admitted.
And so if you could go back to Exhibit 12, I think, 12? No, 13. 13.
Yes.
Would you agree that you both took $5,000?
Yes. She confiscated the check. She would not give me the check. She would give me half of it.
Check was in a joint account?
Yes?
I don't have any more questions.
Okay, thank you. Before we begin cross-examination, let's just take about a 5-minute break, or do you need more time, Ms. Lanier?
No, that's fine.
Okay, we'll be back in 5 minutes. It's 11 o'clock right now. We'll be back at 11:05. Okay. It's 11:10. Are we ready to proceed?
Yes, sir.
Ms. Lanier, cross-examination.
Thank you. Mr. Records, I ask you to look at Exhibit 8.
Who's Exhibit 8?
Her Exhibit 8. I'm sorry. I'm going to be using her exhibits. This is cross-examination. I like to reserve. I could call him as my witness in my case.
Sure.
Okay. Mr. Records, you've identified that check as the deposit money. Was that used for the payment of the house itself?
No,
What was that money used for?
it was used for closing costs.
Okay, so I will go to my exhibits, Your Honor. Exhibit, I think it's 14. 14.
Give me a moment.
It's Exhibit 14.
Okay.
Your Honor, this was previously admitted into evidence at the bifurcation, and I know this is not my case in chief, but can we assume it's admitted into evidence now, or do I have to wait to call in my case in chief?
If it's already been admitted in the bifurcation, then I'm sure there shouldn't be any objection to it already being admitted. Ms. Kirby, is there any objection to Exhibit 14?
No, Your Honor.
Okay, Exhibit 14 is admitted.
Okay, Your Honor, I'd ask, turn to the 5th page.
Didn't it take 3?
No, it's the 5th actual page. Actually, go to the first, yes, it's marked as page 3 at the bottom of the closing statement. Do you see it? It's the 5th page of the document. Does everyone have it?
Yes.
Okay, thank you. Mr. Record, you previously identified this. What is this document?
Closing statement for mission?
Okay, and does it say what the sale price of the property is?
Yeah. Is that it right there? I can't read.
Yeah, do you need glasses?
$550.
Okay, and how much did you put down on it as far as the 1031 exchange?
$270.
And how much was the amount of the mortgage you took out?
$280.
Okay, so does that equal 550?
Yes.
And how much were the closing costs? Well, was it line? Look at line 8.
All right.
What does line 8 say?
Like here.
Line 8. Can you not read it? I'm sorry. It's line 3. I can't read it, and I've got my contact. Yeah. Line 3.
$11,425.71.
Okay, go to the next. Oh.
You're looking at line.
I'm looking at line 1, saying deposit. You see line 1 under.
Yes.
Section, and that, how much was that?
$5,000.
Okay. So if you add the 270 and the 280, the mortgage amount, that's the purchase price, correct?
Yes.
So the $5,000 that was used for closing costs and not the purchase price, correct?
Correct.
Okay. Moving on to exhibit, the wife's exhibit, you can. 10.
Yes.
Your wife signed on the note.
I'm sorry, what are we looking at? 10. 10 of yours or 10 of mine?
10 of yours. Your wife signed on the note and the mortgage because the bank required it, correct?
Yes.
Section calls for speculation, calls for not in
Overruled.
Not in evidence.
Overruled.
Now, per the prenup article 6, were you and your wife required to sign on notes and mortgages and deeds if requested by the other party?
Yes.
Your Honor, assumes facts not in evidence, misstates what the prenuptial says.
I'm going to sustain the objection as it relates to basically the legal conclusion based on the words of the prenup.
Okay. Did you ever intend to gift to your wife the house, the Mission Drive house, or any portion of it?
No.
Now, from the prenup, from the bifurcation, I recall that you said when you did the 1031 exchange, you had to go from like kind to like kind.
I did.
So you went from commercial to what in Naples?
Commercial.
Okay. Were you required to rent the property for a period of time?
Yes, I was.
And how many years did you have to rent it? 2. And after you rented it for 2 years, what did you do?
I moved in and made it my residence.
And when did you move in and make it your residence?
I'm guessing August of 2018.
From August of 2018 to the time you filed your petition, or your wife filed her petition for dissolution of marriage in the summer of 2020, did you ever transfer title in any written form to your wife?
No.
Now then, Ms. Kirby brought Exhibit 13 up, and that was the lawsuit.
Yes.
Did you sign this complaint? Look at it.
No.
Did you ever acknowledge in writing that you were the owner or co-owner of the property with your wife?
No.
Okay. Did you understand the legalese of the complaint when it was filed?
Objection, Your Honor. We are assumed to know what we sign. Objection.
Overruled.
Did you understand the legalese of this complaint when you signed it?
No, I guess not.
Okay. Ms. Kirby also brought up the, let's see, Exhibit 10, 11. Oh, Exhibit 11, her Exhibit 11, which is the note.
Yes.
Okay. Does that confer any ownership interest in the property to your wife?
No.
I'm sorry, what exhibit?
10, 11.
Objection calls for a legal conclusion.
Sustained.
Exhibit 12. You see that, the insurance?
Yes.
Is it your understanding that she was required to be on the insurance because she's on the note and mortgage?
Yes.
Call for hearsay, move to strike.
Overruled.
So as a mortgagee,
Objection calls for a legal conclusion. Objection calls for hearsay. Objection foundation.
Overruled on all.
so in the event, Mr. Records, anything happened to you and then something happened to the property, the bank would be paid, correct? Because Ms. Records is on the note and mortgage.
Yes.
And she's on the insurance policy.
And
sorry.
facts and evidence.
I'm sorry, Ms. Kirby, I couldn't hear your objection. You have to wait for the question to be asked before you object, otherwise you're talking over each other. Ms. Kirby, what was the question?
The question was, and the mortgage would be paid if something were to happen to him. Objection foundation. Objection assumes facts not in evidence. Objection not confusing. Objection improper characterization. I don't see anything like that. And reading. Objection leading.
Proper objections, but I'll reword it, Your Honor.
Okay.
I'm happy to reword it so Ms. Kirby can understand.
Objection calls for calling the opposing counsel.
I'm trying to
Come on,
clarify.
guys.
Thank you. Mr. Records, did the insurance company require both of the mortgagors to sign or be on the title to the insurance policy?
Yes.
Okay. Moving on to, let's see.
Your Honor, I'm sorry, I was on mute. Objection hearsay.
Now, looking at the leases, go to paragraph, Exhibit 18.
Yes.
Who filled that out?
Sharon?
Okay. And did you leave it up to her to take care of the renters?
Yes.
Okay. Did you intend to gift the property to her when she filled this out and said she was a co-owner?
No.
Okay. Exhibit. Did you sign Exhibit 18?
No, I did not.
Okay. So were you aware that she was filling that out as an owner of the property?
Well, it says landlord.
Okay. Well, when Ms. Kirby asked you the question that she signed as owner of the property and you agreed, is it your understanding she was the owner of the property at the time she signed that?
No.
Was she acting as your agent?
Yes.
Okay. Now, let's talk about the account 9337, which is Exhibit 15.
Okay.
Okay. When did you start renting that property out?
Nearly immediately. I would think June or July of 16.
I'm going to go to Beta Stamp Trial 34 of Exhibit 15. Excuse me, not 34. Excuse me. Let me get it. Here we go. Trial 12. Can you go to trial 12? You're looking at it right here. Here.
Okay. Yes.
Do you see a deposit made on 6/1 of 2000?
38.
Yeah.
Yes.
So that would be 2016.
Yes.
Is that the first rental check you received on the property?
I would assume. Yes.
And the $3,800 went into your joint account, correct?
Joint Fifth Third. Yes.
Okay. And who is responsible for making the mortgage payments?
I was.
Okay. And did it come out of this account?
Yes.
Okay. Moving on to the next statement, which is trial 14. Is there a deposit of the rental check into that account?
Yes.
Okay. So on what date was that?
July 8th.
Okay. And was the mortgage paid from that?
Yes.
Moving on to the next month. Trial Exhibit 17. Was there a $3,800 check?
Yes.
Okay. And was it?
Hold on, please, let her finish the question.
What date was that $3,800 deposit?
August 7th. August 2nd.
Okay. And was that money used to pay the mortgage?
Yes.
And how much was the mortgage payment?
I'd have to approximately $2,300 at that point.
Is it fair to say that the rental you received every month from that property exceeded the mortgage payment?
Yes.
And the rest of the money would, after the mortgage was paid, the money would stay in the account?
Yes.
Okay. Moving on to trial 20. Is there a $3,800 deposit made that month?
Yes. October 3rd.
Mortgage paid from it?
Yes.
Moving on to trial 22. Was there a $3,800 deposit?
Yes. November 2nd.
Okay. Paid the mortgage?
Yes.
In November of, I guess, trial 24 was deposits made.
Yes.
And do you know what those two deposits were? You know what they were for?
At 24?
Trial Exhibit 24. Mm-hmm. Do you know what they were?
This is your Exhibit 24, Miss Lanier?
No, sir. It's trial tab for Exhibit 50. I'm sorry.
I don't know.
Okay. But your wife wasn't working at that time, right?
No.
Okay. And both of you deposited money into this account, right?
Yes.
Moving on to trial 25. trial 26 rather, was a $3,800 lease payment.
January 5th.
Okay. How about trial 28 for February?
Yes.
How much?
3,800.
Okay, we can go through this, but every month the rent was deposited into this 9337 account, correct?
Yes.
And every month this mortgage was paid out of the account with the rental proceeds, right?
Yes.
Okay. Exhibit 19, those are 3 checks that were written to just you
Right.
as rental income from a friend who came down and stayed, correct?
Yes.
It wasn't written to you and Sharon Records.
Right.
Okay. Let's see, exhibit 14 real quick. Let's look at the spreadsheet, exhibit 30, husband's exhibit 30. What monies, look at line 2, the 5th, 3rd, 9337 account.
Yes.
What monies went into that account originally when it was opened?
It was opened. When it was opened, I don't know when it was opened yet.
Okay, it was a joint account, correct?
Yes.
And so when you moved to Florida, what monies went into it?
When we moved to Florida,
Mm-hmm. Well, we know the rent money went into it,
right?
correct?
Up until but once we moved here,
Yeah.
then I don't know.
Okay. The account 08, that Chase checking account,
Yes.
number 1, that's the account you've been using
Yes.
primarily. Since when have you been using that account primarily?
Well, my wife designated that she wanted me to use the Chase account, pay all of my bills, and she would use the 5th Third account to pay all of her bills. And that must have happened in, I'm guessing, September or so of 18, after we sold our house in Ohio. She wanted to further divide.
So where was the mortgage paid after you divided that in September of 18? Where was the mortgage paid from?
Well, it came out of that account. It came out from my Social Security.
No, what account did it come out of?
Chase, right?
The 0818?
Yes.
Okay. So the rent, I want to get this clear. The rent, when you rented it for 2 years, went into your joint 9337 account.
Yes.
And that was used to pay the mortgage.
Yes.
Were any marital funds used to pay the mortgage in the first 2 years of the property?
No, it was all rental income.
Okay.
Objection. Calls for.
Can you please restate the question, Mrs. Lanier?
Did any marital money pay down the mortgage the first 2 years after you bought the property?
Objection. Calls for a legal conclusion.
Sustained.
Was 100% of the mortgage paid by the rental income?
Objection. Objection. Assumes facts not in evidence. Foundation. I mean, the record.
Overruled.
Okay. So what is your answer?
Yes.
Okay. Once you moved into the property,
Yes.
what account paid the mortgage?
Chase 0818.
And your wife and you divided that account and the 5th Third account, correct?
That's correct.
Okay. So her Social Security did not go to pay the mortgage after you divided that account, correct?
No.
I'm sorry, Miss Kirby. I thought you
On my objection.
Okay.
Since you separated, and I think Ms. Kirby said it was in late summer of 2020, has your wife paid any of the mortgage?
No,
Any of the taxes?
no,
Does your, strike that. All right. Now, the Capital One money market, the Capital One money market. Well, before I get to that, I think it's important to go to the Sinclair property. The two of you owned a property together before you got married, the Olentangy property, correct?
yes,
After you were married, you deeded it to her per the prenup, correct?
that's correct.
She sold that property and used the proceeds as part of the down payment on Sinclair, correct?
Yes,
Where did the other down payment on Sinclair come from?
came from me.
Did the two of you put about equal amounts into the Sinclair property?
Yes,
And then during the course of the 29 years you lived there, what funds paid the mortgage?
rent from the commercial building, primarily.
And the commercial building was your non-marital property per the prenup, correct?
Correct.
Okay. When the property, the Sinclair property was sold, how much approximately did the two of you receive?
The two of us received 188,000.
And where did that money go?
9337.
So it went into line 2 of Exhibit 30, the Fifth Third 9337 account?
Yes.
And then where did the money go? Was there a time it was distributed elsewhere?
To another Fifth Third account, I believe.
Where did the funds from the money market account come from? Line
7.
7.
Capital One. Came from the Fifth Third,
Well,
9337.
okay.
Plus,
Well, where else did the money go?
was another money market account of 9967
Is that what line is that on the spreadsheet?
6.
Line 6. Okay. So is it your testimony today that line 6 and 7? No. 6 is what she's claiming is the father's money market.
Okay.
Line 7.
What about this disability? I mean, she's claiming it's disability, but that money was all gone.
Okay, that money's gone. So okay.
I mean, just
But all right, but the $125,000 that is sitting in the money market, is it your testimony today that came from the proceeds of the sale of the Sinclair property?
yes.
Okay.
And if you look at that,
What will refresh your memory? Tell me.
I don't think there's a question pending. He asked, he answered yes.
There is no question currently.
Let's look at Husband's Exhibit, I think it's 8. Husband's Exhibit 8.
there you go.
Can you tell me what that document is?
This is dated December 31st of 18.
And who wrote that document?
That's Sharon's handwriting.
Okay. And can you explain what the document described?
I'm sorry, outside the scope. Objection.
We're telling where the money went.
Overruled.
Describe what that is.
It's a ledger of our money. And,
Does it,
she shows fidelity of 152,000, and she shows that must be a joint Fifth Third of 35,000, which oddly enough adds up to $187,000.
well, there's 188
Right.
dash J. What does that stand for?
Joint.
Objection, I don't think it's been, has this been admitted?
No, not yet.
He's describing what the document is, Your Honor. I move to admit it, Your Honor. It's not my
Ms. Kirby? Any objection to Exhibit 8 being admitted?
I don't know.
And
Don't say
No
anything.
objection.
Exhibit 8 is admitted.
Thank you. And that would be Exhibit 8 of the husband's exhibits.
Yes.
So just define what that 188-J is.
Joint.
Well, what does the 188 mean?
It's 188 that we received from Sinclair.
Okay. And does she go on to describe how she makes distributions of that money?
Objection, relevance, negotiations. I'm sorry.
Your Honor, she's claiming.
Overruled.
Go ahead. So describe where that money went, how she divided that money up.
Well, she put, as I said, she put 152 in Fidelity and 35 into the 9337. And then she has 40,000 that she's describing as her dad's inheritance.
That 40,000, how much is that?
40,000.
Can you read it? Okay, 40, all right.
Uh-huh.
All right, so,
This is December of 18.
all right. The ring, let's go on to the ring. You testified that she lost the ring and you got insurance proceeds, but you didn't tell the court when that occurred. When did she lose the ring and you received insurance proceeds?
I would guess early 1990, somewhere in the 90s.
And what happened to that money?
We spent it.
When did you buy the new ring for close to $11,000?
I believe
It assumes facts not in evidence. I don't think he testified he spent 11,000. Objection to the form of the question and assumes facts not in evidence.
it was appraised.
Hold on. I'm going to sustain the objection as the question was worded.
Okay.
Ms. Lanier, can you please rephrase?
Yes. Mr. Records, you subsequently bought a new ring, sorry, for your wife. Do you recall when you bought it?
Objection, Your Honor. Assumes facts not in evidence. He testified before she bought it.
Overruled.
April 9th, it looks like, of 2012.
So 20 years later, you replaced the ring?
Yes.
Okay. And what funds were used to buy the ring?
Whatever Sharon, I don't know, Sharon took it out of something.
Did she have any money on her own? Was she earning any money?
Well, I mean, she took it out of one of our joint accounts.
Okay, that's what I'm asking. Okay. With your approval, correct?
Yes.
Okay. How much do you think the ring is worth?
I don't know.
How much did you buy it for?
I don't know that either.
How much did it appraise for?
11,000.
Objection, hearsay.
Overruled.
Wait a minute, 10,900 it looks like.
And when was that?
April 9th of 2012.
Okay, Your Honor, that would be Exhibit 22 of the husband. I moved that into evidence.
Objection.
Any objection to Exhibit 22 being admitted, Ms. Kirby?
Yes,
What?
hearsay.
Sustained. And actually, before I sustain, Ms. Lanier, would you like to address the hearsay objection?
Hearsay.
Okay. All right.
Do you think the ring is worth $11,000 today?
Probably not. I don't know. I mean,
Okay. Now, Miss Kirby asked you about Miss Records loaning the business money, $20,000. Are you aware at any time there was a shareholder's loan to the business?
no,
Do you recall any records or any tax returns being filed indicating there was a shareholder's loan of $20,000 to the business?
no.
If the business was loaned $20,000, would you personally pay that back to Miss Records? Or would that be a business debt?
The business debt.
Okay. Do you recall at any time Miss Records telling you she was going to withdraw $20,000 or $25,000 from her personal inheritance to pay bills and expect it to be paid back?
No.
When was the first time you found out about that?
Well, when I saw the inheritance account grow by 20,000, I was wondering what kind of investment could you make $20,000 in 3 years.
Were you aware that she had moved funds from a joint account back into her inherited account?
Just when I saw it, yeah.
And when was that?
Well, in one of these distributions.
Would that have been in the last week or two?
Yes.
Okay.
Well, it's just dated.
There's no. That's fine. That's fine. Okay. One moment, please, Your Honor. The cash you have. Did she receive cash as well?
From what? From,
I'm just asking, you have cash, and on the spreadsheet, there's cash as well for your wife. Where did that money come from?
well, yeah, I got, that was from the sale of auto options. She took, we had a safe deposit box in Ohio. She took gold coins out of that safe deposit box and a $20,000 check. And maybe some cash. I'm not quite sure what she took out of there.
But she kept the $20,000?
Yeah, I believe she put it into a safe deposit box with a friend of hers.
Here in Collier County?
Yes,
Your Honor, could we find out when this was?
she told me that. I would say that was, I don't know. Probably late 2016, maybe.
Was it around the time that you took the money out and put it in your safety deposit box?
No, she was here in Florida. She came to Florida. She took the money out of the safe deposit box in Ohio and brought it to Florida, and told me she had taken the money out of the safe deposit box. So maybe, yeah, I'm guessing that was 16.
So are you saying there was a check in your safety deposit box for $20,000
Yes,
and she took that check?
yes.
And did she tell you that she put it in a safety deposit box and cashed it?
Cashed it and put it in the safe deposit box in Bonita Springs with a friend of hers.
Okay.
Along with gold coins.
The closing statement, Exhibit 13, page 113, there's a closing statement.
Yes,
Okay. And you wrote on there Sharon took $5,000.
yes.
Those proceeds were for what?
Damages incurred from Hurricane Irma.
And were they to be used for the repair of the damages?
Yes.
Your Honor, I have no more questions, although I will be calling him in my case in chief.
Ms. Kirby, do you have any redirect?
Yes, Your Honor.
Okay, please proceed.
Mr. Records, can you go to Exhibit 8?
Of husbands or
Wives.
wives?
Yeah, you said that 5,000 went to pay closing costs.
Yes.
Could you have gotten those closing costs if you didn't? I mean, could you have gotten that house if you didn't pay the closing costs?
No.
So it went to acquiring the house, correct?
It went for closing costs. Yes.
From the joint account.
Pardon?
From the joint account.
Yes.
And did you ever testified that after the 2 years you moved into the house on Mission Drive, after you rented it for 2 years, you recall that?
Yes.
Did Mrs. Records move in also?
Yes.
And you testified that you didn't sign the complaint, Exhibit 13.
Yes.
Did you not know that the attorney was filing a complaint?
Yes.
Did you not know what you were agreeing for the attorney to file?
Yes, I knew.
So you didn't sign it, but you knew you were signing that. Did you review it?
I don't recall. I'm sure I did.
Do you think the lawyer just made up on his own that you both own the place?
I don't know. I don't know what he did.
Now, you said you never transferred the title on Mission Drive to Mrs. Records, which is evidence that you didn't give it to her as a gift. Do you recall that?
Yes.
How long did it take you to transfer the deed to Olentangy to Mrs. Records?
I don't recall. 8 months, a few months.
About 3 years or 4 years? Maybe 5? 2? I can't remember. It was about 2 years?
I can't remember either. Sorry. But yeah,
It wasn't something that you thought about. You didn't do it before and you didn't do it this time either.
no.
Okay, and it wasn't held against you that you didn't immediately transfer the deed like it said in the prenup.
Right.
And you didn't transfer the deed here either, right?
Right.
Okay. And you testified that the rent went to pay the mortgage for the first 2 years, right?
That's correct.
But that was an account that your wife only was putting her Social Security money in, right? You put yours in Chase and she put hers in Fifth Third, right?
Our Social Security, that's correct.
Okay. And she had access to that money, right?
Yes.
And as soon as the rent went in, she could have taken it out and used it, correct?
Yes.
And she accepted it, correct?
Yes.
Okay, so let me see. It went into a joint account and she could have accepted it and she did accept it and you lost full dominion and control over it, correct?
Objection, Your Honor.
Sustained.
And you testified at some point you changed the locks on the house.
Yes.
And that's just about the time that Ashley McConnell moved in, correct?
No, I think I changed the locks before that, but I think I changed the locks before that.
And you said, you testified that you were paying the mortgage with the, after, for the 2 months that you didn't have renters, you were paying them, or you've been paying the mortgage with Social Security, IRA, cash, and renter's money, correct?
No, you're saying there was no renter.
Sorry.
No.
You said that you were paying the mortgage, you are paying the mortgage with your IRA, correct?
That's correct.
Okay, can you turn to Exhibit 2, please? And if you could turn to
Thank you.
Oh, this is the prenup?
page 2 of Exhibit 2. And if you could look at Article 7A, and if you could go to F, and it talks about retirement benefits.
Okay.
And so the retirement benefits are supposed to be divided, correct?
Correct.
And so actually, Mrs. Records is still paying the mortgage because it's coming from assets that she would have received if you hadn't paid from that, correct?
I'm not following. She's not paying anything.
You're taking money from an asset that's going to be awarded partly to her to pay the mortgage, correct?
Oh, okay.
Correct?
Correct.
Okay.
I mean,
In effect,
if the judge rules that, yes.
and you want the prenup enforced,
Yes.
and you agree that it says she's entitled to half of your IRA
Yes.
that you're paying the mortgage from.
Yes. If we get divorced.
How do you know that the mortgage, you testified that the mortgage was paid from the rent?
Yes.
If Mrs. Records' Social Security money was put into a joint account and the rent was put into the joint account, how do you know that the money that was paid, that paid the rent, actually paid the mortgage? How do you know it wasn't her Social Security money?
Because it was a larger amount.
So that wasn't used for something else?
It could have been, I guess, the excess, certainly. There was an excess of, $1,300 each month. So, yeah.
I'm going to ask you to look at at Auto Options. Did you guys have on Auto Options have any credit cards for Auto Options?
Objection beyond the scope.
Sustained.
Can I tell you why?
Okay.
He said that the money, he was talking about the money to pay the, from the wife's father's account. It goes to that. If you could give me
Okay, I'll give you a little leeway here. I'm not sure how it goes to that yet, but I'll overrule the objection for now.
Okay. Mr. Records, did you have any credit cards at Auto Options?
Yes.
What was the name of the credit card?
I had Chase Visa, I believe, and I had American Express. I think those were the only ones.
Do you have a Capital One?
Maybe, yeah.
Was Capital One a personal card? I apologize. Was Capital One a personal card?
I don't know. I don't recall having a Capital One, right? I should say I don't recall using a Capital One.
Did you use Capital One to pay $500 a month for Google ads for Auto Options?
Still objection relevant.
Sustained.
I'm going to ask you to turn to Exhibit 15, page,
Here. Oh, this is 16. Do you have 15?
I have 15.
Well, no, it's the loose one. Here it is right here.
Okay.
Trial 56 at Exhibit 15.
Okay, I have it.
And if you look at the equitable distribution sheet, you can see that Mrs. Record's father's, the account that she says is her father's is 9667 at Fifth Third, correct?
Where are you looking?
I'm just asking you, is 9667 Mrs. Record's account? That was her dad's account, where she got her dad's inheritance.
Objection calls for facts not in evidence.
It's in the ED worksheet. Okay, if you don't know, that's fine. I'll get it in through my client.
Okay.
Check, that's all.
Sorry, did you say that's all, Ms. Kirby?
Let me check.
$10,000.
You can hear you.
I'm sorry.
That's all.
Okay. All right. The time is now approaching noon. It's probably good for a time for a lunch break. Ms. Lanier, Ms. Kirby, do you anticipate calling your client next, or what's your?
Yes, my client.
Okay. She'll probably be on for a while. So I guess here's the two options. I have a couple of hearings I need to do at 1:30. We could either take a break to about 1:45, or we could come back here at 1, get at least 30 minutes of testimony in before having to take that break.
I would prefer to do that. I mean, I'd like to take as much time as we can.
Okay. Let's make this then a quick lunch break. I'm going to endeavor to get back here at 12:45. Is that sufficient time for all the parties?
That's 45 minutes, sure.
Okay, we'll get back here at 12:45.
Your Honor, I just have a housekeeping.
Yeah.
When we make our legal argument today, I for the first time was hearing about a gift. I'm doing research as we're doing the trial. So I'll try to get to the case law before. I mean, I have some already, but are you expecting to make a ruling today, or are you going to allow us?
I may be able to make a ruling on some things. I may not. Based on the way this is going, I think probably what's going to happen is I may be able to make a ruling on some things, and the things that I'm not, I may require, rather than closing arguments, post-trial briefing with using the case law, as that's probably the best way to go for most of the stuff. I've heard a lot today, and there doesn't seem to be actually too much in the way of questions of fact. But that's where I'm sitting here today, right before lunch. That's what my thought is. But
so I don't have to prepare anything during lunch to get to you in the next couple of hours.
I don't know how I'd read it in time.
That's what I'm saying, Your Honor. I don't have to do it right now, is what I'm saying. I'll have it for you, but you're not going to make it like 4 o'clock or 5 o'clock. I have to give it to you, right?
That's my plan.
Okay, thank you.
All right.